All right, so the unauthorized practice of law. Now, at the outset, you might think, well, it's pretty obvious. You need a license to practice law in a particular state or particular jurisdiction. What's the issue? Well, there are more issues here than you think. I see the unauthorized practice of law, not a lot, but I do see it, and I do see it in surprisingly experienced attorneys. I have a case right now where I have brought an action in a New York federal court. The defendant is a resident of another state, and the attorney representing the defendant is licensed to practice in that state, but obviously not licensed to practice in New York. He formally appeared in the action as the attorney for the defendant. I was shocked. I obviously brought it to the attention of the court, and for reasons that I don't know, not aware of, the court took no action. That's the most egregious one I've ever seen. And the unauthorized practice of law not only is an ethical violation, it's a crime. So the fact that you're an attorney in another state doesn't mean you can practice in this jurisdiction. That should be obvious. The other thing that I see more often is practicing in a court in which you're not admitted. So maybe you are admitted to practice law in the state of New York. You have a license from our court's highest, or our state's highest court. But you're not admitted, say, in federal court. Or if you're admitted in federal court, maybe you're admitted in the Western District of New York, but not the Northern District of New York. Lawyers seem to just appear, and depending on the judge, it can be a problem. Some judges, they don't take it too seriously, which I don't understand. Other judges will say, "Counselor, are you admitted to practice in my court?" Well, not technically. Have a seat. That's how it should be handled. There is a way, however, if you're not admitted in a particular court, that you can be deemed admitted for that particular action. And that lawyer in that case I told you about could have easily done that. It's called pro hac vice. And what it means is, for the purposes of this particular action or proceeding, you are admitted to practice before that court. You have to have somebody locally, an attorney, to quote, sponsor you, and you have to fill out the paperwork and you file it with the court. There's an order, the order is signed, bingo, you're admitted. You can do everything that any other lawyer who's admitted in that court can do. It's not a big deal, and it's a way to do that. The other thing that arises, I think, in these cases is, what is the practice of law? And it's a nebulous term. It's not well defined. You'd be surprised that what is it that we do that's considered to be the practice of law? For example, the practice of law involves giving advice to our clients. Now, the obvious first example that I gave you, where you can't appear in a court that you're not admitted, that's obviously the practice of law. But what about advising somebody? What if your client is in another state and they ask you for some advice? The courts are split on that. Some of them say that does constitute the practice of law and you can't do that. Others take a different view. My feeling, however, is if my client's in another state and they're asking me a question that might be based upon that state's law, I'm not so concerned about the practice of law. I'm concerned about the fact that I'm not really qualified to advise them on that state's law because I'm not familiar with it. So I stay away from that. The other thing that you can't do is you cannot aid a non-lawyer in the unauthorized practice of law. And where this arises is with usually legal assistants or paralegals, whatever term you would like to use. They feel a little bit freer to do things that lawyers do. And you have to supervise them, obviously, but you have to be very careful what task you give them. And you have to supervise them because, especially if you're in a specialty practice and it's a service that you render over and over again, that paralegal is probably going to know the answer to most questions. And you'll be surprised. Many clients will have no problem asking a paralegal a legal question. Now, I don't think I would ever do that. I would want to talk to the attorney. But most clients, in my experience, have no problem doing that. But here's the point. Even though the paralegal may know the answer, they cannot advise that client. Now, what's the difference between providing information and providing advice? It seems to be this. If that person is exercising his or her own personal independent judgment, then that is advice, and that's practicing law without a license. Here are the set of facts. What do you think I should do? Danger, okay? I have a hearing. It's at 10 o'clock. Should I be there at 9:30? Okay, that's different. So there's a line there, and if that paralegal crosses that line, remember the paralegal is not subject to the Code of Professional Conduct. You are. And you have an obligation, ethical obligation, to make sure that you're not assisting a non-lawyer in the unauthorized practice of law. What about drafting documents? Well, if it's kind of fill in the blank stuff, I mean, you've already drafted the template and the person just inputting data, name, address, that kind of thing, that's going to be okay. If that person is in any way drafting the document using independent judgment and how that document should look, that's probably crossing the line. I know this stuff is nebulous and there's nothing you can grab your hands on, but there's just some markers that you can keep in mind. What about settlements? A paralegal, a non-lawyer, has no business ever engaging in any kind of settlement of anything ever. There was a lawyer in our town, boy, this goes way back, probably 20 years, who had a personal injury practice. And what they found out was this lawyer had several paralegals who were settling these cases with the insurance adjuster. That lawyer lost his license to practice law. That's the unauthorized practice of law, and he not only permitted it, he set it up. There are some states that have different rules for law students. So if you're a law student, maybe you're a third-year law student, you might be able to do something that a non-lawyer couldn't do. It's kind of in the middle between the non-lawyer and an admitted attorney. You're not going to be able to appear, but some states allow law students to do things if they're enrolled in an accredited law school that non-lawyers could not do. So these are some of the things you want to keep in mind to avoid the unauthorized practice of law.